Yeah, you can get them all invited. I think that works.
Oh.
Sheldon. Oh, you.
No, yes, that's
That's not a picture.
Yeah.
Change the camera, yeah. Yeah, you can do what it worked. I was just, but check when you finish. Alright, let me get this all. I kind of liked it. I know you guys all say.
You guys ready?
Yeah.
No, not. Oh, yeah.
Out of state.
Almost there. Step on.
Stevens.
Yes.
I have a choice to stay, but I want to stay. Good morning. Yeah, thanks. So, all rise. Court's in session. Judge Monroe presiding.
Everyone, happy
Morning, Judge.
Wednesday to you.
Yes,
Please be
happy
seated.
Wednesday.
Morning, Judge.
You weren't there yesterday, were you?
I was in trial.
Oh,
I'm in trial in front of Judge Weiss.
okay.
Today's closing's at 10. I had to
Sure.
come see you today, though.
I'm glad. I'm glad you came to see me today. What case are you here on?
First case up, Your Honor, page 6, Jotham Terry, 25 CF 009269. We're here for a status and have a plea conference jail to transport tomorrow.
With
Actually,
Judge Collins?
I don't think we have dockets.
I don't know.
I got
Judge Collins.
I have a case. I have a case.
Can we set it for Friday?
We can set it for Friday or Monday. Friday or Monday. Friday.
Which one do you want?
Friday. Great.
Friday.
If we have a case on Friday, if not, we can set it for
Let's do Monday.
let's do Monday.
There we go.
Monday is safe.
Monday or Friday?
Monday.
Okay. Monday it is.
Thank you. Next I have Miss Kayla Brown, 25 CF 007890.
What page?
2, Your Honor. We're here for a plea conference. I'm gonna set this for a status read DCF.
You want to set it for a status?
Yes,
When?
30 days out.
That's fine, Judge. What's Monday's date? You know?
Monday is
February 13th?
thank you.
Oh, wait, that's not 30 days out. Sorry. 30 days out is February 27th. Does that work?
That works, Judge.
Yes,
Thank you.
thank you.
February 27th? Deputy from Corrections, can you come sidebar? No. No, we're gonna schedule it down the road, like end of February, March, things like that. Yes? Okay. Do we need to do a transport order? We need a transport order? Okay. Oh. This, Barboza. I'll be right back.
Thank you.
Okay, Josh. They're here for Semmie Williams.
Yeah, but everything that they reported, just make sure you're talking. Like, things from, yeah, they're not. Everyone important to hear me.
Order?
Morning.
Morning, Your Honor.
Case.
So Judge, on top of page 7, this is Thomas Villanos. We're here for a motion hearing filed by the defendant.
Case number 24CF10124. Yes?
Morning, Judge.
Morning, Judge.
Renee?
Good morning, Your Honor.
For the record, Douglas Duncan, Tamma Cudman, and Albert Santoro. Mr. Santoro will be arguing the motion for the defense.
Okay.
And Francine Edwards, Matt Kimball on behalf of the state. And we also have with us the attorney for the next of kin who has a notice of appearance in the file as well. He's also filed something that was sent to chambers. It was a formal objection.
Yes, I have.
May I proceed?
Please.
Good morning, Your Honor. Today's motion is to ask for an order allowing the defense to examine the decedent's cell phone and his Apple Watch. First, I'm going to tell the court what we are asking to look at, and more importantly, what we're not asking to look at.
If I could interject with a question.
Of course.
Does the state have this material?
So the cell phone and the smartwatch were recovered from the decedent's body at the time of the crash. However, the contents have
didn't
not been
extract-
entered. They
you
have not
haven't
been extracted. Correct.
Go ahead.
The second part, Your Honor, I'm going to explain to the court why the defense is asking for this. And then the third part, I'm going to tell the court the methodology and the safeguards that will be in place for that examination.
Here's my question to you. Well, I appreciate counsel's giving me the Constitution. I did look it up and I know that there's a right to privacy. The decedent's not the party here. So how is it that you can obtain information from the decedent's possessions when the decedent is not a party and has the expectation of privacy? This is not like a civil lawsuit where the decedent is a party seeking damages, and so therefore they open themselves within reason to discovery. Here he's not.
Your Honor, I would argue to the court that in the criminal context, the criminal defendant actually expands the rights that would go beyond in a civil lawsuit. In particular, Your Honor, number one, that evidence is held by the state attorney's office. The state attorney believed that those items were important enough and did not release them to the family. Secondly, Your
But
Honor,
it's the cell phone. I mean, I don't think the state has a problem giving you the cell phone. They don't want to give you the contents of the cell phone, which I just asked them. They said they don't have the content.
and Your Honor, what I want to explain to the court is what we are asking for versus what we're not asking for. If
Okay.
I can just have
Certainly.
the court's indulgence. Your Honor, we're not asking for the specific contents of communications or text messages or app uses. We are, the decedent was wearing, and Your Honor, this terrible tragedy, we understand the sensitivities of the potential contents that are in the watch and the iPhone. But the decedent was wearing this iWatch at the time of the accident. He was also wearing a pair of gloves, leather gloves. One of the gloves in his right hand, which presumably he was holding the watch in his right hand because all of his other possessions were in a zip bag. The glove was removed from his hand sometime during the accident or the collision, and the cell phone was found not very far from that. So what we're looking for, Your Honor, is just if the phone was being used. What I have for the court, I have two exhibits. It's not in dispute that the decedent was not in the bike lane at the time of the collision. He was actually in the lane of traffic, even though there was a bike lane. And I'm going to show first to the state one of the exhibits that was CSO Linzaris, who was at the accident and documented the scene. She had supplied a diagram showing where the decedent was when he was struck. And with the court's permission, can I approach the bench, Your Honor?
Yes.
Your Honor, it's looking at a diagram prepared by one of the state's main witnesses, and it shows that the bicycle was in the lane of traffic The second exhibit that I'm going to show the state is from the deposition of eyewitness Richard Roschbacher. Richard Roschbach. Do you have any objection? May I approach, Your Honor?
Yes. Thanks.
Your Honor will be so kind as to look at the circled portion of the fluorescent paint. You will see a blue circle indicated with an arrow. One of the facts that is not in dispute, both the state's expert and the defense expert place the point of impact squarely within the lane of traffic. Both the initial interview of this state witness by the police officers and the investigators and the subsequent deposition by which also I want to point out that Mr. Blumberg was present at that deposition as well, have the witness seeing the bicyclist, the deceased, in the bicycle lane initially. And he testified that at some point, he was no longer able to see the bicycle in the bicycle lane. The defense's position in this case, and it's critical here because it's a homicide, Your Honor. This is a vehicular homicide. It's an unintentional homicide, and that's why it was charged as a reckless. And I want to point out, it's not a DUI homicide. So we're talking about reckless conduct here. If the decedent was on the Apple Watch, or he was receiving a phone call at the time, or he was using one of the functions of the Apple Watch, that may go to explain why he suddenly left the bicycle.
To be succinct, you want to know if there was any activity on the iPhone or the Apple Watch at the time of the collision?
Exactly. We don't want to know what the activity
Okay.
was,
You got-
just if he was using.
You got me there.
Okay. Thank
Response?
Judge, the only problem with what counsel is proposing is that regardless of how distracted the victim was, it is not a defense to this crime. Specifically in the jury instructions, you'll see it says the conduct of the victim or another person is not a defense to this crime unless the conduct is the sole cause of the crash. Since we're doing show and tell a little here, if I could show Your Honor a photograph of the bicycle embedded in the defendant's vehicle, I'll show that first to defense counsel.
I have no objection, Your Honor.
Yes, ma'am. So my question to you, Ms. Edwards, and I understand that it may not necessarily be a defense, but is that not in a discovery phase something that the defense could be entitled to, just knowing the activity, whether the phone was active and in use at the time?
Well, Judge, anytime we're talking about impinging on some of the most protected areas, as Your Honor knows, as a criminal judge, the most protected area is the home. The second most protected is a person's cell phone because we live our lives there. Counsel is not asking for records from the phone company to determine whether or not the victim was utilizing the phone or not. He would like a download of the cell phone. There is no way to parse through a cell phone download other than to do a whole physical download of a cell phone and parse through it. And so the request, even though it's attempted to be limited by words today, it's not possible. There would have to be quite an invasion into the decedent's privacy rights to even accommodate what defense counsel is requesting. And in addition to that, there are the issues about whether or not this information would even be relevant, because Your Honor is right that discovery rules permit a wider source than admissibility. But at the same time, if it doesn't matter whether or not he was on the cell phone, whether or not he was running around cars or whatever else was the cause of the crash, then that is really an important analysis for whether or not in this balancing act of privacy versus the defendant's right to know, whether or not it is important enough to impinge on the decedent's right to privacy. I do know that Mr. Bloomberg wishes to be heard, if Your Honor would permit that as well.
And may it please the court, and thank you so much for hearing me this morning. I represent the widow, long-term marriage, and the mom of a 1-year-old and a 7-year-old child who very much want to protect the privacy that goes to their husband and their father. And they do not waive that constitutional right of privacy, and it extends beyond death. And we cited the case law that says that, Supreme Court case that says it. Right now, the only motion that we're appearing on here today is a motion to conduct what's called a Cellbrite examination of the phone and the watch and the Apple Watch. That is an extraordinarily intrusive type of examination where they get in, they seek to unlock it. It's like opening up a filing cabinet. It's opening up the life of the decedent, and there could be embarrassing things in there for the widow. And this is where it's just the case law has made it clear that cannot be the first attempt. That's not the first thing you do to try to establish information. We've heard today that maybe they want something different, but that's not what they asked for. That's not what we're here on today. They've not contacted us for any type of a meet and confer as to try to work something out. Is there some way that we could try to have something done less intrusive? But right now, what they've asked for is really forbidden. The Fourth District Court of Appeals has made that very, very clear in the case of Menke versus Broward County School Board. A search of an electronic device should not be the first means of trying to obtain discovery. There's so many safeguards. There's so many other things we do. We take a lot of time with the court. I wish they had called, tried to have some meet and confer, the hearings right now. So we'd ask you.
Here now.
We
All
would.
the hearings should have happened.
May I respond, Your Honor?
And if I could just real quickly, if I could just finish up. So based on the motion that's in front of the court today, we'd ask the court to deny the motion, but deny it without prejudice. We'll be glad to meet and confer with them, see exactly what it is they really want, what other type of less intrusive means might exist. Do we have to do an in-camera inspection? I don't know. But for what they're asking for today, we'd ask you to deny it, but deny it without prejudice.
Thank you, sir.
Yes, please. Thank you.
Your Honor, Mr. Blumberg is representing on the civil side. My sister law firm and my wife is representing the family on the civil side. I want to remind the court, he doesn't have standing today.
I would object to that.
Filed a notice of appearance.
Your Honor, but a meet and confer is a civil.
No, it's not, sir. Not in this circuit.
I apologize, Judge. First, let me talk about the safeguards. First, the safeguards. Your Honor, we will consent to have the phone examined at the Palm Beach Sheriff's Office. And if Your Honor wishes, it can be an in-camera inspection. So we want to send our expert or an expert selected by the court just to find out if it was being used at the time. And Your Honor, I want to point out, even though this is a reckless charge, I think the state are arguing that even if the decedent pulled out a microsecond before impact, that somehow the defendant would be guilty of reckless conduct when no one would be able to avoid that. What we are trying to show is at the time of impact, what was happening? Was he on his phone? Why did he deviate? The state's own witnesses say that he suddenly left the lane. So in order to prove reckless, it has to be reckless by an objective standard. That's one part of this. The second part, Your Honor, and I haven't argued this part, the time of death is very relevant in this case because I know what the state is going to be arguing, that it was a long and suffering death, and it's a terrible tragedy. But the Apple Watch contains the exact moment of death. It has a heart monitor, and it will tell us the exact time that the decedent's heart stopped. In addition, Your Honor, the Apple Watch has an accelerometer. And what an accelerometer is it's a electronic device that measures speed and direction. So the watch will also tell us how fast was the decedent going. Did he stop suddenly before the impact?
You can ask the attorneys behind you. We had that whole issue when we were on television all of last week concerning the decedent's cell phone then. So I'm pretty familiar with all of this.
So I'm not going to
and-
belabor
yeah.
my argument. Your Honor, I want to protect his privacy as much. Every time I heard about the children, I have a 3.5-year-old, Your Honor. Every time I look in his eyes, I see the decedent. If something happened to me and my son was fatherless, we do not deny this is a terrible tragedy. We just think blame is misplaced. So, Your Honor, we will go along with whatever procedural safeguards the court wants to ensure. We do not want the content. We only want to know if it was used. And I think there's a way that the court can fashion a solution to protect everything that Mr. Blumberg and his clients are looking to protect. I don't think the state should have an argument in this race because the state is trying to prosecute my client for a homicide. So anything that would give information as to speed, direction, time of death, all of these things are very relevant.
Let me just make sure I'm clear. You represent the widow.
Yes, Your Honor, I do. I represent the widow and the children in the estate. It is in the estate, yes.
Anything further?
No, Judge, I think you've heard enough.
Concerning the motion to conduct Cellbrite examination of alleged victims' Apple Watch and cell phone. As to the Cellbrite examination, that is denied without prejudice. There are least restrictive means by which the defendant can obtain the information it seeks without obtaining the cell phone and downloading the contents thereof. For example, in my civil days, you sent a subpoena to the cell phone company, asked for activity 15 minutes before, 15 minutes after. You would have the activity, and then you would be able to determine whether or not there is any information for you to glean before you can actually go download it. So that's my ruling, please. If there's an order necessary, so be it.
And for the record, the state would have no objection to such a subpoena.
Thank you.
Thank you, Judge.
Thank you for your patience in hearing us today.
Have a good day, sir. Thank you.
Your Honor, may we have leave to issue that subpoena?
I mean, that's not part of the motion. I'm just offering that out. I think there's a mechanism in place for the issuing of a subpoena, and I believe there's a window by which people can object again. So
Thank you.
follow that procedure. Next case.
Morning.
Good morning.
On page 6, we have Semmie Williams, 21 CF 9692.
Good morning, Joe Walensky on behalf of the state.
Morning. So we're working on scheduling. As you know, today's my last day in this division. I'm moving to family in Delray. The Delray Beach Courthouse does have a holding cell, does have a recording mechanism like we have here. So in all likelihood, we could do the sentencing there. I'm working with PBSO to find out if that's a possibility. Then we would coordinate with you to see if you all can make the trek. The Atlantic Avenue has really nice restaurants. You can come down to Atlantic Avenue and do the sentencing there. So that's the plan.
Okay.
Right now, there's a lot of moving parts. I just finishing my felony work, learning family, and Mr. Williams is trying to mesh my calendar suspension dates with the family docket that's already in existence to kind of carve out that time. Once he's able to do that, he's going down to Delray next week to meet with our predecessors to kind of get all of that information, and then we'll be able to coordinate a date for sentencing. I issued an order, hopefully you all received it, asking you all for sentencing memos. When you produce the sentencing memos, I would ask perhaps you could tell me how much time you all need for sentencing so we can factor that all in as well.
We talked about it today. We think about an hour and a half.
Okay.
Yeah.
So,
Total.
Okay.
so I think we could still put it in the memos.
Yeah, just
but-
for as a reminder, that would be
Sure.
helpful.
Sure.
Anything else that you all want to address?
Can we? I just don't want to lose track of the case.
We won't.
Okay, I'm worried about not having a future date is my only concern.
I understand that. I'm trying not, because I'm not going to have the division anymore, so I don't want to put things on Judge Collins's docket that really are things that we need to do. We are working with IT to see if we can derive a report. So I identify all of the cases in which sentencing is mine, and then we'll put it on my family law docket so that it does sort of get tracked. I really am working on all of that. It's just, I was in a trial last week, as you all may know, and, working through all the other transition things. So I promise It won't slip through. 23rd. And on the FX docket? Okay, so Mr. Williams, my judicial assistant just checked in. He's gonna put a status check. My new division is FX, Family X, on that docket, and we'll be able to keep track of it that way.
Okay.
I don't know how it'll be the
Can
same
appear via
case
Zoom?
number, but
And we can appear via Zoom on that.
for what?
For the stat, I think he said it would be a status.
Yes, yes, you can appear by Zoom for that.
Okay.
Unless Mr. Williams wants to be here.
Just for status, I don't think so.
I don't know,
Right.
but you'll let me know.
Yes.
You can appear by Zoom. If Mr. Williams is appearing in person, then that's coordination. All right?
Yes.
Okay. All right. Thank you all.
Thank you. May I approach her just?
Yes, ma'am.
Thank you.
Next case.
Good morning, Your Honor.
Morning.
Page 5, I can call up Colin Sellers, case number 25 CF 5663. He's present here in custody.
Is this a plea?
So for this one, Your Honor, we are waiting on certified convictions from Texas to confirm to see if the score on the score sheet is correct. Mr. Edwards ordered them about a month ago. Still haven't sent it to us, so we just need a little bit more time to get those convictions. 30 days probably. Hopefully they get it to us by then.
February 27th. Does that work?
Yes, Your Honor.
Okay.
Thank you.
Thank you.
Should we, can I get a different attorney?
You have to put something in writing for that. You can't do that orally.
What is it?
You have to put something in writing concerning that. You can't do that orally. When you go back to the law library at the jail,
I have to request a different attorney.
you have to do it in writing, sir.
Yes, ma'am. Also, not that I'm the one that like decides how proceedings go, but shouldn't we just 30 days is obvious, whatever y'all are doing, but shouldn't we wait till Texas actually sends the classifications as opposed
We're
to?
just making sure we have something on this docket so that it doesn't slip through the cracks, so that if something happens before the February 27th date, then they'll take the necessary action. If not, then they'll just tell the judge that's taking the case, taking this division, kind of what's going on, so we can make sure we're keeping track of this case and we don't lose you in the jail.
Yes, ma'am.
All righty, sir. Thanks.
Yes, ma'am.
Morning, Your Honor.
You're welcome.
I can address Ms. Shania Corker on page 2 of Your Honor's docket. Oh, I'm sorry. I'll address the next one. It's case number 25CF008007. Ms. Corker is present in the back. We're set for a plea conference, but it's not going to be a plea conference. I'm still waiting on discovery. I have to review a video with Mr. Gorlicki, and this might be a negotiated plea down the line. So if we can actually set this for a plea conference, perhaps in, I would say 60 days, so that I could just make sure I have all the videos and send him the mitigation for potentially a PTI misdemeanor or something else.
Speedy's waived.
Speedy's waived.
And I just want to clear up the record. We did send discovery back in December and emailed the defense that we sent it. Just the videos you guys are missing, right?
Correct.
That's,
which
yes,
is
that's what I meant. They're just
discovery.
waiting on the PBSO.
So 60 days,
I would ask for 60 days. Yes, Your Honor.
Mr. Gordon.
That works for the state, yeah.
March 16th.
Perfect. Thank you. And then, Your Honor, I could also address David Liggins. He's on page 3 of Your Honor's docket. It's case number 25CF000883. This is also set, Mr. Liggins is present in the second row. Set for a plea conference. This is a VOP. This is not going to be a plea conference. We're asking just to track the new law. He has court tomorrow. And
a new law violation.
it is a new law violation.
Has court tomorrow in the new law violation.
Yes, Your Honor. It's a misdemeanor that he's taking to trial. So,
This can't track that.
well, I think if he's found not guilty, the state advised they would withdraw the affidavit. If he's found guilty, then it would be an
So you-
admit,
so I don't-
reinstate.
You said it's set for, there's a court event tomorrow, but it's not trial tomorrow.
It's a plea conference tomorrow, but he
In a
is
misdemeanor case.
correct.
So do you want to come in following week or do you want to come in?
If we could just set it for a status the following week, and waive his appearance, that way we could just advise of a court date because he is setting it for trial at the court hearing tomorrow.
Second or the week of the?
Either week works. Doesn't matter to me.
Would you come in February 9th?
Thank you.
It's for status, madam.
Thank you.
Thank you.
Good morning.
Morning.
On first page of the calendar is Marquand Barnes. This is a motion to reinstate his bond. Did you get a copy of the motion?
Yes,
Okay. Have you had a chance to review it?
yes.
Okay. Then I don't have much more to add other than what I
Who's here
put
for
in
the
there.
state?
Logan Edwards, Judge.
And these are case numbers 25-2142, 25-2147. Yes, he is in custody.
Mr. Edwards?
Yes, Judge. So just wanted to point out, so the original charge of fleeing and eluding happened, the probable cause affidavits, and I'll provide them to you in a moment. The first one happened in February of last year, and then the possession case, which was later consolidated, was March. That was filed on later. And it was filed, I have the original information here. I believe the original information, you can correct it if I'm wrong. So April 25th of 2025, the information for possession of counterfeit blank Ford's motor vehicle and driving while suspended. That was April. And then December 18th, the new charges were filed in this case. So that's the second case. He has the fleeing and eluding, which is the original. And I probably should have started there. Was filed, let's see. That was originally filed April 16th as well. So both cases were filed originally. I believe his bond was revoked due to a new arrest that happened in November, Judge.
Are there 3 cases or 2?
The third case, the arrest in November, which that was the basis for his bond being revoked, I believe, or it was revoked at that time, was a domestic. That case was no filed. However, at the time, the judge found at first appearance as probable cause for that offense. And as we know, and I feel it's not necessary to point out because while he's out on bond for 2 cases, he's not supposed to pick up any arrests, and they found probable cause for that. I do have here, and I've showed to defense counsel the probable cause affidavit.
For the domestic violence?
Yes.
Okay.
So as it happens at first appearances, they found probable cause. We chose not to file it. And that is the state's filing decision. But an independent third party, the judge found that there was probable cause, which is a violation of conditions of pretrial release. And given that it was domestic, I do not feel that it's appropriate for bond to be reinstated. He has 2 open cases, Judge, that.
What's his prior criminal history?
Yes, his prior criminal history have right here. I have like 10 files. Prior criminal history, he has misdemeanors, 1 adjudication, 1 withhold, 4 prior PTIs, Judge. So that's just on the fleeing and eluding original case. So he doesn't score on that charge, but I haven't ran the new calculation with the new charges as well. But he was on pretrial release, supposed to be on his best behavior, and picked up an arrest, and probable cause was found. So I don't think a modification of bond is appropriate. I think he should be continued to be held no bond on these 2 new felony cases, or these 2 felony cases that have been filed originally. They've been changed, but since April, they've been filed. So for those reasons, that's really the state's argument.
What are the degree felonies for these?
Yes, so the new one is a 2nd-degree felony, a 3rd-degree felony, and then the original fleeing and eluding, which was a 3rd-degree felony. So he's facing, if those
Wait,
were.
isn't it 4 charges on the,
No, Judge, so there was an amended information.
Filed in December after that arrest.
So it's a little bit confusing. In this case, it was originally a drive.
this case, which one?
I'm sorry, in 2147.
Okay.
There was originally a driving on a suspended license and then counterfeit registration charge. They arrested Mr. Barnes again with 6 new charges on another case. They then consolidated those charges into 2147. Null prost the DUS and the registration. And then only 2 of these are alive due to an amended information. That is count 1 and count 2.
The sale and the
Unlawful use,
Yeah,
correct.
which
but
means
also,
second and third.
yes, those are relating back to charges on, or occurrences that happened on March 15th. So it's not like they amended charges at a later date. They amended it at a later date, but not for something that occurred later.
And then the fleeing and eluding, is it a second or third?
Fleeing and eluding, it's a
Let's say third.
Correct, Judge, a 3rd-degree felony. So he's got a 1st-degree 15, or a 2nd-degree 15-year and 2/3 at 5 each. While I don't bond for those picked up for domestic.
Currently, his bond status is what? I mean, never mind. Bad question. Before it got revoked, what was his bond status?
Okay, so before on the fleeing and eluding, it was a $5,000 bond. And then on the original charges in 2147, that was the DUS and the registration, those were 1,000 each. So those have now been null prost and they've added other charges. And on these 2 charges, let's see, 25,000 on count 1 and 5,000 on count 2.
Okay. Does that complete everybody's argument?
Yes, I would just, the only other issue was paragraph 4 of the motion about his medical condition. He's not getting all of his medications. He is getting an anti-seizure medication, but there are other medications and we're seeking medical records to provide at a later date if needed, but we'd like him to be out to be able to get his regular medication.
And just for that, Judge, jail, as we know, provides medication treatment, even for, we've had colostomy bag treatment in front of us before. So I know the court's well aware of the treatment jail provides.
Okay. Concerning the motion to reinstate bond, it's granted in part as to 25 CF 2142. Bond is now increased to $15,000 with in-house arrest. As to 25 CF 2147, bond is increased as to count 1 to $45,000.